All right, let's jump right into this explainer and unpack what is honestly a fascinating constitutional showdown. We're looking at case CCT 34/99 from the Constitutional Court of South Africa. At its core, this whole thing is a story about timing, missed chances, and the absolute necessity of keeping the courts moving. When you're dealing with massive fundamental changes to a nation's laws, the mechanics of how and when you challenge those laws, that matters just as much as the challenge itself. I mean, imagine walking into a movie theater right as the credits are rolling and just confidently asking the projectionist to restart the entire film from the top just for you. That is essentially the legal equivalent of what happened here. The applicant tried to get the highest court in the land to literally hit the pause button on a highly complex, multi-province judgment that was already at the finish line. And the court's response? It gives us this incredible behind-the-scenes look at how judicial systems fiercely protect their own machinery. Section 1. The urgent latecomer. So our story kicks off in the final days of September 1999. The Cape Metropolitan Council has just lost a massive high-stakes case in the Cape of Good Hope High Court. And the issue? Nothing less than the complete restructuring of local government in South Africa, specifically under the new Municipal Structures Act. Now, the council wasn't just disappointed, they were constitutionally alarmed. Guided by their head of legal services, B.K. Keizer, they were absolutely convinced this new act unlawfully stepped all over their municipal autonomy. In fact, Keizer argued the act was wholly unconstitutional on two major grounds, specifically pointing to conflicts with sections 155 and 160 of the Constitution. Those are the sections dealing with how municipalities are established and run. So they felt their very existence, their institutional integrity, was under direct threat. Section 2. 3 bold requests. Defeated in the High Court, sure, but they were determined to keep fighting. So they rushed to the Constitutional Court on September 30th. And they didn't just ask for a simple appeal. No, they came armed with 3 highly specific and honestly pretty audacious demands, what lawyers call prayers. Now, the first 2 were standard enough for an urgent matter. They wanted the court to hurry up, and they wanted a direct appeal. But that third prayer? Absolute jaw-dropper. They asked the Constitutional Court to literally stop the presses on 2 other major pending judgments, the Western Cape and KwaZulu-Natal cases, until the Council's own appeal could be heard. Basically, they wanted the entire justice system to just wait for them. Section 3. The parallel cases. To really wrap our heads around why this was such a wild request, we have to zoom out and look at what the Constitutional Court had been up to for the previous 5 months. They weren't exactly twiddling their thumbs. They were already deep in the trenches on these exact same constitutional issues. The Western Cape and KZN cases, those were instituted way back in April and May of 1999. The court even held intensive 2-day hearings in late August, with 3 senior counsel battling it out for provincial and national governments. The issues were completely, thoroughly canvassed. And yet, our latecomer, the Cape Metropolitan Council, drops their urgent application on September 30th. That is weeks after the final arguments in those other cases were entirely wrapped up and the judges had literally already gone off to write their decisions. Well, the response from Deputy President of the Court, Justice Langa, was as definitive as it gets. He made it crystal clear that the court had already done the heavy lifting. He pointed out that the main decisions had been in preparation for weeks and were quite literally ready to be handed down. The gears of justice were already turning. Granting a pause at that exact moment would cause totally unjustified delays to vital national matters, especially with local government elections and the demarcation board looming. Section 4. The missed opportunity. Now, you might be thinking, hey, maybe the Cape Metropolitan Council just didn't know about those other cases. But actually, the case documents reveal a huge twist. They were perfectly aware of the Western Cape and KZN cases. In fact, Keizer's own affidavit admitted that the council's lawyers actually attended the August proceedings in the Constitutional Court just to watch. They literally sat on the sidelines and observed, instead of getting on the field to play. And here is the crucial point. If they truly wanted their unique local government perspective to be heard, they had a built-in legal mechanism to do exactly that. Under Rule 9, they could have applied to join the proceedings months earlier as an amicus curiae, a friend of the court, but they completely ignored that proper established avenue. They chose to wait until after they lost their own high court case to try and derail the Supreme Court's entire schedule. Section 5. The court's final verdict. So, a unanimous constitutional court, featuring incredibly respected legal minds like Chaskelson, Ackerman, Goldstone, and Sachs, all concurring with Justice Langa, had to strike a balance. They had to weigh the strict rules of court procedure against the undeniable importance of this local government restructuring. And the result? A brilliant yes-but pivot in judicial economy. First, the court delivered a firm smackdown to the delay tactics. Prayers 1 and 3, the urgency, and the crazy request to pause the other judgments, were dismissed entirely, with costs. But pivoting pragmatically, they left the door cracked open for the actual substance of the complaint. Instead of throwing out Prayer 2, the request for a direct appeal, they just postponed it. Because local government restructuring was so vital to the country, the court fairly decided that the council shouldn't be completely locked out of justice just because of some really bad timing. So they gave the applicant a specific 7-day window. And the logic here was elegant. They essentially said, go read the massive judgments we are handing down today in the Western Cape and KZN cases. Once you've read them, you have 7 days to supplement your application and tell us if you still actually have any unique constitutional complaints left to pursue. This case perfectly encapsulates a massive tension that exists at the highest levels of law. It leaves us with this final, critical thought to really ponder. At what point does waiting to hear every single perspective stop being about fairness and start becoming a roadblock to actual justice? The Constitutional Court showed us here that while the door to appeal can certainly remain open, the clock of justice, it waits for no one.